Yes.
matter. There's one criminal appeal. It's a conviction under POCSO Act, my lord. But so far my client is concerned, he is convicted not because of committing of the crime. He was convicted because the girl says when she raised hue and cry, adjacent room he didn't help. That's the reason you are convicted for 20 years. So filed the appeal. Also along with the appeal, I filed a bail application. The Honorable Court on Election told me that we'll direct for a paper book, preparation of paper book, then direct for like placing the matters on orders. Now paper book has been prepared. Now matter is, my lord, can it come of orders for considering the bail, my lord? That is
Okay,
only prayer.
next week.
Next week on 13th, my lord, can it be, my lord?
Oh, give it to the court master.
Yes, my lord.
May I
Yes.
please, Your Lordship, I wish to mention for listing one IA for consideration of bail, my lord.
Okay, give it to the court master.
Obvious.
May it please your lordship, I beg to mention for listing one criminal appeal
Or
for motion
motion.
and urgency is that they're considering for bail. Bail consideration
Okay, it
for
will be listed. All criminal appeals are listed in an urgent manner.
bail.
When did you file?
It filed on 23/6.
23/6.
Six.
It must be lying defective.
We have
Address the
complied.
defects.
We complied the defects. We complied the defects.
Then it will be listed.
Any date listed.
Okay, Lekhak. Continue next week.
Any other request?
Lordship, I beg to 7. Lordship.
Yes.
I beg to mention item number 6 for adjournment, Lordship. My senior is not so well today. He's sick.
6 and 7.
My lord, I am for the 7 appeal and Milord.
Okay.
In this case, my appeal and Milord, there's a bail earlier I filed Milord. We have not placed his health conditions deteriorated. So my short date may be fixed for hearing Milord to this.
Lordship, it can be taken on 18, Lordship.
Okay.
19, Milord.
Mr.
SN Ahmed, Lordship.
S.N. Ahmed, learned counsel for the appellant in 6 has made a prayer for adjournment. First of Mr. P.K. Deka, learned counsel for the appellant in 7, and Ms.
Baidu.
B. Bhuya, learned senior counsel and additional public prosecutor for the respondent state are present. First of, as sought for by the learned counsel for the appellant in 6. And as agreed to by the other learned counsel for the other parties, come and list the appeals on 18.
Obliged.
Daily list for orders. Item 1.
May I please your lordships? Lordship, this IA is for condemnation of delay.
This application under section 5 of the limitation 1963 is preferred, seeking condonation of delay of 70 days in filing the accompanying appeal under section 39 of the Special Marriage Act, read with section 19 of the Family Code Act. Against the judgment and decree dated 16/6/2025, passed by the Court of Learned Principal Judge, Family Court, Dhubri, in F C T S within bracket D, case number 931 of 2024, whereby the petition seeking dissolution of marriage by the appellant has been dismissed. Issue is returnable in 4 weeks. Applicant shall take steps for service of notice upon the sole respondent by speed post within 3 working days from today.
Supplementary list. Item number 8.
Lord, in this case, paper book has already been prepared. The matter is ready for hearing. There is only one request from my end, my lord. If your lordship can kindly fix an early date for hearing.
2025, it will go by usual course.
No, only.
2025,
No,
we are dealing with appeals 3-4 years.
I can understand because under section 32B of 32A
Make
of
an
the
application
NDPS
for urgent listing, that is a different thing. Third, Mr. D. Goswami, learned counsel for the accused appellants, and Ms. B. Bhuya, offense is under 302.
No, 22C of the NDPS Act.
Oh. And Ms. B. Bhuya, learned senior counsel and additional public prosecutor, assisted by Ms. Yes, Ms.
J. Saikia.
J. Soikia, learned counsel for the respondent state. The paperwork is ready. First of raised serial is the appeal for hearing in usual course. Make an application for urgent hearing.
Item 9.
Maybe.
Yes, this is for what?
I for suspension of sentence.
Suspension of sentence. Yes, whether materials are all in English.
English ত আছে নে vernacular?
English.
Saisa.
Vernaculars are also there, which we have placed it.
Then for this man's paperwork will be
My lord.
a necessity. For me, it is no difficulty.
Otherwise, we have annexed the 161 statements along with the criminal appeal. Lordship,
161 statement has no
Lordship, because
161.
yes. Lordship, because the primary witnesses have turned hostile, therefore 160. I will also refer to the 161 statement. I am raising for the
What about the FIR and all?
FIR, Lordship. We have translated. It is in Thamis at.
So better the paperwork be ready.
Lordship, for today, I am raising the plea of insanity, Lordship. He is a known case of patient for mental illness, Lordship.
Huh?
He was from 2016 was suffering from mental illness. We raised the plea of insanity before the trial court, but it was not considered. Lordship.
To
Therefore,
us, which point of where you raised? At the time of commission of the offense or at the time of the
no,
trial?
Lordship. From 2016, he was receiving treatment in the AMCH.
What evidence you have brought?
Lordship, all prescription, Lordship, the opinion of the doctor is also there in one of the prescriptions. And moreover,
It's in the.
moreover, Lordship, on 22/3/2022, he was crime was committed, but he was not taken to custody. He was directly taken to the psychiatric department of AMCH. Lordship. More than 1 month, he was kept in the psychiatric department. Thereafter, he was taken to custody after 1 month, 3 days.
If you're suffering from illness.
So, 2016.
Incident happened in 2020. He was been in treatment from 2016.
And in the 161 statement, every vital witnesses have mentioned this fact in the evidence also in chief also.
Let the paperwork be ready.
Lordship.
Lordship, for once, IA page 94, Lordship may see the opinion of the doctor. Lordship, in the top brief case history, Lordship, second point, known case of psychiatric illness since 2016.
Where is the FIR?
Lordship, FIR at page. Lordship, FIR is at page 49.
Contents to put. Contents is at my lord, definition, I don't know. 61, 52, 52.
52 is the.
Who lost this?
His elder brother lodged it. Afterwards, Lordship, because of his illness, Lordship,
Yes,
his elder brother later applied for bail, Lordship. When
That is a different thing. Where is the judgment?
judgment page, it starts page 13, Lordship.
30.
At para 33.
Well, let us have that page 44. Defense exhibits nil.
No, that is one
Right.
problem. Yeah.
And the prosecution exhibit. See. Exhibit 1. 2. One is seizure. 2 is Ejahat. 3 is post-mortem. 4 is, I don't know, 4.
There's
What
no
is 4?
4.
5 is
There's four.
inquest. 6 is command. 7 is dead body. Chalan.
Yes, Lordship.
Exhibit 8 is fire. Then exhibit 9, sketch map. 10, arrest memo. 11, final report. Where is the evidence?
Lordship, yes, Lordship, that is.
No evidence is laid. We have to appreciate the
Lordship, that is the point.
testimony of the witnesses.
Lordship,
This cannot be now brought in.
no, Lordship, one thing, that is one problem. The-
Problem is
The defense.
crucial. The issue is crucial. Is it not?
Yes,
If you have raised the plea of insanity, right?
yes. At para 33, we have raised it, but
Well,
without.
we
any-
have dealt because when the
Yes,
issue
it is
comes,
On record, Lordship. that
when
is
the
true.
matter comes,
Yes,
death of a relative and the prosecution and the accused is also a relative,
Son.
son, and the prosecution witnesses are also brothers, sisters. It is very easy to raise this issue of insanity. We have to deal with one case because it is sometimes it is an afterthought.
Lordship, in the eye of.
Mr.
Yes, Lordship,
There is no evidence as on such.
Yes, Lordship, that is true.
Then how
Before the
could
trial.
we cannot read those. We cannot read those. Think it whether this plea can be raised at the stage of appeal. Otherwise, we have seen few of the witnesses turned hostile. By nature, mother killed by brother, all witnesses are brothers and sisters. Everybody turned hostile to save. Okay, with the feeling, mother is gone. Now let him be there. Any single piece of document. Otherwise, other things are matter of appreciation of evidence.
Yes.
Now it is not there. No document to support,
Yes, Lordship, that is true.
right? And you have brought some external documents now.
Otherwise, why?
Let the paperwork be ready. Had Mr. B.P. Bora learn it. Counsel for the accused appellant and Ms. B. Bhuyan. Learned senior counsel and additional public prosecutor assisted by so and so. Naam to jane na? The respondent number 1 state. Who is Miss U.S. Bora? Mr. U.S. Bora. You are for informant. You might be sailing with him.
No. I find Mokalatama on behalf of the informant.
Are you filing an objection to the IA?
No, not.
Not, you are not filing.
But I don't have objection.
That I know. Before saying, I could know.
Lordship, otherwise also.
For the respondent to inform it, first of all. As the TCR is received, office to prepare the paperwork, first of this the case after 4 weeks for the report regarding readiness of the paper. I লিখিব interrogatory application will be considered, will be given a consideration after preparation of the paperwork.
সাইফুলটো ল'ব লাগে না?
Further matter for hearing.
External
10.
document, we are not going to look into.
Lordship, I was to rely on the statement of the IO, Lordship. That much.
আগতে
IO.
3 লো। 10 to লো।
Maybe you may have a good case.
Item 10 for hearing.
Number 11.
So, Postal is needed. Extra copy আছে? Extra copy? Postal যাবে লয় One person. Forgot everything. Huh? From the evidence on record, including the testimony of the witnesses, it has emerged that the incident had occurred on 12/8/2011. And the deceased Kanu Karmakar expired on 14/8/2011. It was on 14/8/2011, the FIR was lodged. Posto. The deceased Kanu Karmakar breathed his last in the house of
Informant.
informant SPW1, Srimati Sefali Korpukar Rajpur and her husband PW seven. PW seven. Birgu Rajbor. Full stop. It was after the death of the deceased, comma, police person from Philovari police station visited the house of PW1 and PW7. On 14/8/2011 and sent the dead body for postmortem examination to Philovari State Dispensary. Full stop. The postmortem examination on the dead body of the deceased was performed at Philovari State Dispensary at about 3 p.m. Sorry. Where is the doctor?
Almost 3 p.m.
Uh,
Page
Where is the inquest? Inquest. 40.
40. Page 40 is
Ayo. Visited the place, visited the house of PW1 and PW7. And found the dead body on a bed. Full stop. At first, comma, the conducted inquest proceeding in the house of PW1 and PW7 on 14/8/2011 and prepared an inquest report within bracket EXT1. So stop thereafter. The dead body was sent to Philovari, Tinsukia Civil Hospital for postmortem examination. The postmortem examination was performed at Tinsukia Civil Hospital on 14/8/2011 itself by the Senior Medical and Health Officer, PW6 post. As per the testimony of as per the testimony of PW6 and the postmortem examination report, PME report, EXT2, there was contusion of the head on the frontal area of 3 cm into 5 cm, and on dissection, blood was seen under the scalp post-op. A linear fracture of 10 centimeter was found on the frontal bone, extended up to left parietal bone. It was opined that the death was due to shock and hemorrhage resulting from injuries sustained. And the injuries were caused by blunt force impact and were antemortem in nature. The date was opined to be homicidal in nature. Date which occurred 12 to 18 hours earlier, was opined to be homicidal in nature. Para. It was PW two Lalu Karmakar, who testified that he saw the accused assaulting the deceased. PW 3 stated that he did not know who assaulted the deceased. PW testified to the fact that the accused had assaulted the deceased with a bamboo stick And as a result of the assault, the disease fell on the road. Subsequently, the disease was taken to the house of PW1, wherein he was stated to be treated by a village doctor who administered saline and injection to the diseased. Postdoc. Oh. I'll come back. Postdoc. The disease was not given treatment in any health facility during the period from 12/8/2011 to 14/8/2011. Postdoc. It has been urged by the learned counsel for the appellant that as the disease died after 2 days after assault and he died after a lapse of time, after a lapse of 2 days, without any treatment in a health facility. And only after receiving treatment from a village doctor, the injuries sustained might not be sufficient to cause death in the ordinary course of nature. First off, it has been urged that had the diseased received proper medical treatment, the possibility of the disease surviving would not be ruled out. First off. It is not readily acceptable that where death occurs after a lapse of few days, the injuries which had caused the death would take out the offense out of the purview of culpable homicide. Rustam. Each case has to be decided on the basis of its decided on the basis of the facts and circumstances obtaining in the case. Rustam. The main the important aspects of consideration is the nature of injury and whether the injury is sufficient in the ordinary course of nature to lead to death. Full stop. The adequacy or otherwise of medical attention may not be a relevant factor in a particular case. Full stop. In this connection, the following observations made by the Honorable Supreme Court in Prasad Pradhan and another versus the state of Chhattisgarh, SCC is high level, I will let you. Can be referred to. Here at para 25-26. Para. Coming back to the facts of the case in health, it is evident from the testimony of the autopsy Dr. PW6 and the postmortem examination report, EME report, EXT2, that the death of the disease was due to shock and hemorrhage resulting from injuries sustained, and all the injuries were caused by blunt force impact and were antemortem in nature. The death was opined to be homicidal in nature. The issue which has therefore arisen is whether as contended on behalf of the accused appellant, the case of the appellant is The case is not of murder as the evidence on record points towards the factors required to bring into operation exception 4 to section 300 IPC. Post on. Murder over any murder. যে culpable homicide আৰু murder বুলি যে লিখি দিম। Next, culpable homicide is a genus and offense of murder, comma, is its species, comma, meaning thereby, comma, all murders are culpable homicides, but all culpable homicides are not murders. Full stop. To bring in a case of culpable homicide within the scope of and ambit of murder, comma, the conditions of any of the clauses prescribed in section 300 IPC, comma, that is, comma, either firstly or secondly or thirdly or fourthly, comma, are required to be satisfied. Full stop. Section 300 IPC reads as under at a para 34 para IPC. There are also 4 exceptions, 5 exceptions, 5 exceptions provided in section 300. Full stop. If an offense, despite fulfilling all the conditions of any of the clauses stated therein, comma, comes within any of the exceptions, then the offense would be culpable homicide, not punishable under the first part of section 304, comma, IPC. The exceptions are exception 1, 2, 3, 4. Explanation it was. Then you have para 35. Admonition. Para the intention to cause death can be generally can be gathered generally from a combination of few or several of the following, among other, circumstances. One, nature of the weapon used. Two, whether the weapon was carried by the accused or was picked up from the spot. Three, whether the blow is aimed at a vital part of the body. Four, the amount of force employed in causing injury. So and so, there are 37. Para. From the testimony of the prosecution witnesses, as well as from the defense witnesses, it has been established that it was PW1, PW2, PW3, and PW and the deceased who, after an incident which occurred in the morning hours of the day, 12/8/2011, leading to the beating of PW3, proceeded towards the house of the accused in the evening hours on that day itself to question and confront the accused as to why he had beaten PW3. The place of occurrence was nearer to the house of the accused than these prosecution witnesses and the deceased. Postal. It was at that moment, the accused and his family members confronted the PW1, 2, 3, and the deceased. Full stop. The accused confronted, wielding a bamboo stick in his hand. Full stop. There was quarrel between the two sides. First, And thereafter, a fight erupted. A fight ensued. Full stop. As the side of the accused took the upper hand, all four of them, P21, P and the deceased, tried to run away in different directions. It was in such situation, the accused inflicted the blow on the deceased. And as a result, the disease fell on the road. Full stop. There is nothing on record that other than one blow on the disease on the head of the disease, which is obviously a vital part, no other injury was inflicted on the disease. Full stop. The injury, though, resulted in contusion of the head, leading to a fracture, which appears to be sufficient to cause death in the ordinary course of nature. The fourth exception of Section 300 IPC covers acts done in a sudden fight. Full stop. The exception is founded upon absence of premeditation. Full stop. In order to bring in a case within exception 4, comma, there must be evidence to the effect that there was heat of passion which clouded a man's sober reason and urged him to do deeds which he would not have otherwise done. Full stop. There had to be a provocation. And it is not necessary that the injury done is a direct consequence of that provocation. Full stop. To bring in exception 4, for exception 4, there has to be no previous deliberation or determination to fight. A fight suddenly takes place, comma, for which both parties are more or less to be blamed. It may be that one of them starts it, comma, but if the other has not aggravated it by his own conduct, it would not have taken the serious turn it did. There is then mutual provocation and aggravation, and it is difficult to apportion the share of blame which attaches to each fighter. The help of exception 4 can be invoked if the death is caused A. Without premeditation, B. In a sudden fight, C. Without the offenders having taken undue advantage or acted in a cruel or unusual manner, and D. The fight must have been with the person killed. To bring a case within exception 4, all the ingredients mentioned in it must be found. The word, comma, fight occurring in exception 4 to section 300 IPC is not defined in IPC. Full stop. It takes two to make a fight. Full stop. Heat of passion requires that there must be no time for the patient to cool down, and the parties had worked themselves into a fury on account of the verbal altercation in the beginning. A fight is a combat between two or more persons, whether with or without weapons. It is not possible to enunciate any general rule as to what shall be deemed to be a sudden quarrel. It is a question of fact, and whether a quarrel is sudden or not must necessarily depend upon the proved facts of each case. For application of exception 4, it is not sufficient to show that there was a sudden quarrel and there was no premeditation. It must further be shown that the offender had not taken undue advantage in a cruel or unusual manner. The expression undue advantage as used in the provision means unfair advantage. Full stop. In this connection, a reference to the decision in Dhiraj Gorakhbhai Nayak versus State of Gujarat 2003 9 SSC 322 can be made. Full stop. Para. From the evidence on record, comma, sorry. From the evidence on record, comma, it has emerged that there was no premeditation on the part of the accused appellant, as it was PW 1, 2, 3 and the deceased who proceeded towards the house of the accused. First up, a sudden fight ensued, a sudden quarrel followed by a sudden fight ensued between the two sides. Thereafter, first up, in the process, comma, the accused gave a blow on the head of the deceased with a bamboo stick. Full stop. But other than one blow, the accused did not inflict any further blow. Full stop. On the deceased. Full stop. From the above discussion made, para, and the reasons assigned therein, comma, we are of the considered view that the case is one which comes within the scope and ambit of exception 4 to section 300 IPC, as the accused had caused such bodily injury, comma, which led to the death of the disease after 2 days, comma, and such death was caused by the accused without premeditation in a sudden fight, in the heat of passion, upon a sudden quarrel, and without the accused having taken undue advantage or acting in a cruel and unusual manner, comma, he is guilty of the offense of culpable homicide, not amounting to murder. Under the first part of 304 IPC, full stop. Thus, comma, the conviction of the accused under section 302 IPC is not found sustainable in law, full stop. We therefore, comma, hold that the accused appellant to be guilty for the offense under the first part of section 304 IPC, full stop. His conviction under section 302 IPC is, comma, therefore, comma, is set aside, full stop. Having held the accused guilty of the offense under the first part of section 304 IPC and taking into account the obtaining facts and circumstances in its entirety, including the fact that The accused was a youth of about 25 years of age at the time of commission of the offense with no prior criminal antecedents. Come aware of the considered view that the sentence is required to be altered as per section 304, part 1, post of. Was this one code, sir? Was this one লিখা আছে না? Second in supplementary, no? Supplementary. Not yes. It is stated in the bar that accused appellant has spent more than 11 years in incarceration. As on date. Undergoing the sentence of life imprisonment, as ordered by the trial court. Full stop. Insofar as the conviction of the accused appellant under section 323 IPC is concerned for committing the offense of hurt to the informant PW1, the testimony of PW1 is supported by the medical evidence adduced in the form of testimony of PW9 and the medical examination report from a EXT3 poster. In presence of such evidence, the conviction and sentence passed against the accused appellant calls for no interference. Full stop. Para. Or taking into um, uh, order, we have to consider view that we are of the we are also of the considered view that the period already spent by the accused appellant till date will subserve the ends of justice. Uh, the period, period, uh, already spent by the accused appellant in incarceration. Huh? Undergone by the so will subserve the ends of justice against his conviction under 304 IPC. There is, however, no alteration as he has the amount of fine to be paid by him. And the order as he has fine, is passed by the trial court, is maintained. Post stop. Para. The instant appeal stands partly allowed to the extent indicated above. Post stop.
There's no big deal.
Huh?
Whatever.
Huh. The jurisdictional district legal services authority is to consider the matter of granting appropriate compensation to the victim in terms of the provisions contained in section 357A CRPC and the extant victim compensation scheme, framed there under full stop. The records of the trial court are to be sent back forthwith. Oh, maybe not possible.
Pandya.
Is the other cases in the list? Huh? Is anybody ready? It does, no? Miss Priya,
My lord, maybe take it up on some other day.
other day, can you inform the other sides?
Son, मुझे ना दे.
All three judgments are to be corrected and
Right.
uploaded. And I'm not
Lordship is not there.
feeling well. Or should we see that too?
My lord,
Huh? Okay.
Four and five.
we'll inform the other side. We'll inform.
Only three cases, two,
Hmm.
two, four, and then from the other side. That's it.
Huh?
Phone call.
Call out now.
And two. And two for you. Two. And three. Wait, hello, four. Tiwari was there.
He was there.
Yes,
We
where
need
is Tiwari? Call Mr. Tiwari. And MS Bormon, also M. Bormon.
Meghali bar phone course.
Tiwari is 7 years, 9 months. Oh, I'll do.
Final video. I said.
Hmm.
I said
That is why I have called for that.
to Friday night.
It is possible. Mr. Tiwari, we are not in a position to take up your appeal today. We are disposing of 2 appeals today. Some other day. Your sentence is, you are in
7
custody
years.
since 7 years. So, okay, we'll fix it on a date. A Tiwari learned amicus curiae for the appellant and
So liquid it enough.
B. Mia, Senior Consolation Public Prosecutor for the respondent state. Of shortlisting in the case appeal on. Okay, we have anything on 2nd of December?
Oh no.
Hello.
Promo Kusana Koto Bumya.
2nd of December.
212.
Release the case appeal accordingly on 2nd of December. Yes, Ms. Borman.
We fix another date.
You are for under custody, in custody 4 years. Okay. 4th of December.
Month.
4th of December. M. Borman, huh?
Jahanuddin.
Amicus. Same. Okay.
Public.
Okay, 2 counsel is not there. Left over. Mr. Chaudhary,
I appreciate what has been told earlier.
due to sudden,
I will not mind.
deterioration and rising fever,
Yeah.
next Thursday I will do complete.
13th may not be convenient, your lordship.
We have heard you
But
just
then
13th.
at 3 p.m. only.
3 p.m. Oh, 3 p.m.
Next on the 12th, no?
You do all your business earlier in the first part.
sometimes the business gets delayed in court.
We'll accommodate.
Oblige.
I'll be sitting in single bench, so
13th.
release the case on Thursday. Case will be taken up at 3 p.m. As part of, release the case on so-and-so as part of. I intend to, but could not.
I appreciate these are the
Sudden,
practical difficulties.
sudden